Is it possible to live in the UK if you have a child? If you presently have a child that is under the age of 18 and who is either a British citizen or is settled in UK, you may be able to apply to come into the UK or remain in the UK if you are presently in the UK. You may also meet the requirements for leave to remain if you and your child are in UK and your child has resided in the UK for 7 years even if they are not presently a British national or possess an indefinite leave to remain.
The UK
points-based
immigration system.
ending free movement.
But change is coming. Change is coming.
It is essential to note that, in all scenarios, you might not be eligible for a spouse or partner visa, as you should apply via the partner route if your spouse or partner is a British national or is settled in the UK. You cannot apply straight through the parent route if this is the circumstance. So, assuming you are not entitled to apply as a spouse or partner, you can apply for a visa as a parent of a British child to arrive into the UK if you 1. Meet the suitability obligations in Section SEC Appendix FM, and 2. Meet all the lawful obligations which are relationship requirement, financial requirement, English language requirement. You must be over 18 and your child must presently be under 18, residing in UK, and a British national or settled in UK. You should also have sole parental responsibility for the child, or if you have mutual responsibility, the other parent must be a British national or settled in UK, not your spouse. You must prove that you possess sole parental responsibility for your child, or you have access rights to your child. You are taking a vigorous part in the child's nurture and will carry on to do so. Financial obligations. You should be able to prove that you will be able to sufficiently uphold and adapt yourself and your child in the UK with no recourse to public funds. You should also prove that you will have satisfactory lodging available in the UK with no recourse to public funds for the family, which the family own or lodge solely. English language obligation. Except you are a national of a common English-speaking country, for example United States of America or Australia, you should be able to prove that you have good knowledge of English by one of the following paths. Pass an accepted English language test in speaking and listening with at least level A1 of Common European Framework of Reference for Languages, or have an academic qualification equal to a bachelor's or master's degree or PhD in the UK, which was tutored in English. Applying to remain in the UK. If you are presently in the UK and desire to switch to or extend your visa in this category, you can apply for leave to remain as a parent of a child in the UK if you are presently in the UK on a visa, which is effective for more than 6 months, and are able to meet the obligations. If you cannot meet the obligations, you may still be able to apply. Children over 18. If your child is currently over 18, you are even now entitled to apply for an extension of the visa, if your child was not 18 at the time you were initially provided the visa in this visa category, and they are not now heading an independent life. Paragraph X1. Paragraph X1 of Appendix FM of the Immigration Rules provides an exemption to rules involving family members of British or settled individuals in the UK. X1 can be useful to leave to remain applications, where a person has an authentic and existing parental relationship with a child who is under 18 years old, who is presently residing in the UK, who is a British national or settled in the UK, or has resided in the UK successively for a minimum of 7 years before the date of submitting the visa application. It would be rational to imagine the child to depart from the UK. Also note that if EX1 does apply to your scenario, you are excused from meeting the English language and financial obligations. Allotment of visa, 5-year or 10-year route. If you meet all the obligations, the visa will be allotted for a time period of 2.5 years, and you will be allowed to apply for indefinite leave to remain after a constant period of at least 5 years in the UK on the parent visa. So if you are permitted this visa for the first time, you will be required to apply for an extension, and after 5 years you will be able to apply for ILR. If in spite of this, you applied under the EX1 exclusion, you will be put on the 10-year parent route. So this would denote you would be required to make 3 further extensions after the first time the visa is allotted to meet the criteria for indefinite leave to remain. Our video ends here today. Don't forget to comment below if you have any questions regarding UK visas and immigration. Thanks for watching today's video update.